I would like to see that.
Okay, folks, we're going to get started. I'm Dave with having the board members here. I've also introduced another fine attorney specializing in construction law. He doesn't do divorce. He doesn't do wills and probate. He pretty much keeps our asses out of trouble. So let me introduce you to J.P. Vogel.
Hey, morning. All right, so.
Wait, hold on.
Yeah.
Come, let's give him.
Thank you, Dave. Appreciate it. I've known Dave for quite some time now, and nothing's changed. Appearance or personality. So I appreciate you guys spending time with me this morning. This is a really exciting topic, right? Talking about mechanics liens and claims. It's a world where people have a lot of questions, right? And there's a lot of there's a lack of confidence amongst contractors about how do they manage their mechanics lien process and how they deal with getting paid. Obviously, one of the single largest issues that we deal with. So before we get started, like who in the room is accustomed to dealing with mechanics lien issues? How many of y'all routinely file mechanics liens now? A little bit. Mechanics liens? No, mechanic. Sorry, the microphone. So how many of y'all file mechanics liens? You do, and you do it confidently?
Not on every job.
Not on every job. Okay. And y'all guys have kind of a cutoff about dollar amount and project type and all that?
More like it's
Okay. And does anyone in here ever file mechanics liens related to residential projects? Oh yeah, wow, that's fun. Okay, so, and we can talk a little bit about that too, because we'll go through this process and I want y'all guys to ask questions about residential mechanics liens because there's so many problems associated with it, so many traps, and so many hoops you got to jump through when it comes time to actually foreclose those liens and make them actually enforceable. You'll see what problems you got to deal with. So big picture for Texas projects. When we're talking about extra contractual rights to receive payment, you're talking about mechanics lien statute, talking about payment bond statutes, public and private, right? And then there's also a federal mechanics lien statute called the Miller Act. If you guys are ever working on federal projects, doing any type of roofing work on any federal type project. We're also going to talk about the Trust Fund Act, which you guys should all be aware of, the Prompt Payment Act, which is also a great tool for you, and then just breach of contract notices. All right, so talking about liens. I go through some of this stuff. It's really self-explanatory, but some of the reasons why people file liens, there's a dispute between the GC and the owner, there's a dispute between subs and GCs, there's bankruptcy filed on a project, which impacts payment, flow down of payment, and then you've got non-payment. Okay, so common reasons liens are not filed, which always hurt my head. But there's a lot of contractors that choose not to file mechanics liens because they think it'll damage their relationship with the person that feeds them work, even though they don't understand that the person that feeds them work takes advantage of that and oftentimes will screw you over when they have to and it's convenient for them, and then you're out of relationship and you're out all the money. So that's a huge reason why I see liens not filed. Also, there's the issue of people feeling like they've missed deadlines or they just feel like there's some issue with their balance and there's a dispute and they don't want to initiate a dispute with an owner. Sometimes people are afraid of the cost of it and the complexity of it. Like I said, when I asked who does it confidently, there are a lot of people that don't even do it because they think they're going to get in trouble if they do it wrong. So I can go over the complexity of it, but it's not really that necessary. It's obviously complicated. If you ever pick up the property code and read chapter 53, you'll want to put it down after about 2 minutes. It's just too much. That's true for many lawyers too. And residential versus commercial, whole different set of rules. That even goes down to the basics of how did you contract with an owner, right? Did the husband sign? Did the wife sign? Did you give them a 3-day right of rescission? Did you have all the notices and warnings in the contract? Did they sign it at their residence versus at your office or any other location? There's all these outs for residential owners if you file a mechanics lien, for them to get out of it or defeat a mechanics lien. This is talking about the new mechanics lien statute. Our law firm has a state rep named Jeff Leach, who's in the Texas House. Jeff Leach is a huge champion of the construction industry, obviously practicing in our construction group at Gray Reed. And Jeff is kind of the liaison between contractor associations and the state legislature with upgrading statutes that impact our industry. All right, so this is a part of that process. You'll see as we go through the changes to the mechanics lien statute, some positive changes that'll help you guys navigate this issue. And you can see that it passed 141 to 1, okay? And the one vote against it was on accident. And the Senate passed 30 to 0. So this also applies to, it's not really so relevant now, but this only applies to contracts that were signed after January 1st, 2022. The old mechanics lien statute applies to anything that's before that. So the only time this is going to apply is if you have a large ongoing commercial project that predated that date, all right? Computers. All right. 3 steps for filing a mechanics lien. You get the pre-lien notice. Oh, man. You have the lien affidavit itself, and you've got the post-lien notice. All right. Very self-explanatory. There are requirements in the statute that we're going to go over that prior to filing a mechanics lien, you must send notice to the owner and the original contractor, giving them notice that you haven't been paid, 15th day of the 3rd month, file the mechanics lien affidavit, file a lien, send a notice within 5 days of recording the mechanics lien. And we're going to go over all that stuff. So there's 2 categories of lien claims: lien for progress payments, lien for retainage, different timelines, different requirements. Okay. Pre-lien notice, and I'm rushing through it all because I kind of, in my mind, I simplify a lot of this stuff, and I think you should too. I just think if there's money owed, you treat it like that. Don't distinguish it in your mind. Don't make it complicated, all right? Pre-lien notice fund trapping letter. The old statute had requirements about what you include in the notice, when you had to send it, and it triggered the responsibility for the owner to say, I can't pay out any more money related to this contractor's balance, right? So if you're working for a GC on a commercial project and they owe you $15,000 and you haven't been paid and you send notice, the owner has to withhold $15,000 in any payment going forward relating to you on that project until you reach a resolution. The new statute says this is all you got to send. They literally put this in the statute, okay? This is all that has to be in there. It's that simple. You could put a company letterhead and you could cut and paste this into it and handwrite in the information in the blanks, and that's all you got to send. This is it now, okay? It's very, very simple. So you have to send this by the 15th day of the 3rd month after work was performed. The old statute, if you were a sub of a sub or a supplier to a sub or whatever it might be, you'd have to send by the 15th day of the 3rd month. Then you'd have to send notice by the 15th day of the 3rd month to the owner. Okay, you had to notify the GC, tell them I hadn't been paid. Then you had to notify the owner, tell them you hadn't been paid, and then you had to file your mechanics lien affidavit. So you're tracking 2 different time frames on a chart. Also under the old statute, if the 15th fell on a Saturday, you had to file it on the 14th on the Friday. And that also threw a lot of people off and invalidated tons and tons of mechanics liens. Now, if you file it, if it falls on a Saturday, you can file it on a Monday. All right? Way more liberal construction. Go ahead.
When you say work was performed, can you be more specific? Because there's different work to be performed in the office or out in the field. I mean, there's all kinds of different work.
Yeah, you know, the whole mechanics lien statute's premised around the concept of if you improve real property, right? If you help benefit and improve the value of someone's real property or their structure on a property, that constitutes work. I will tell you that for purposes of filing a mechanics lien, I am extremely liberal about what I constitute that. And so if a contractor has done any type of punch work, any type of gone out there and replaced something, fixed something, dropped materials off, that constitutes.
What about contacting insurance companies or anything?
I'd stay away from that.
Okay, any kind of office work notice, actual work on the job site.
It's really actual work on the project site. That's really like if you step foot on the project and you do something out there that you think is invoiceable, I would constitute that as the last day that you did work on the project.
So the problem with that is with some like with insurance claims, it could be another month or two before the insurance process is settled up, where
Yep.
they get money to get paid. So you would have to follow them before they even are responsible.
We'll get into strategies about filing liens. I think there's a real simple way to deal with it, okay? And we'll go over that. And I don't want to brush by it. So when we get to that point, talking about tactics, we'll talk about that. There's also rules for specially fabricated materials we're going to talk about. And in roofing, that can become an issue. So here's what it used to look like, where it X'd out, doesn't exist anymore. That's all you have to track on the right. It's way easier, okay? And I'll share this presentation with anyone that wants it too, so you have these charts. So basically the idea is, right, if you do work in January, you drop materials off of the project in January, along the way you should be getting paid. If you're not getting paid and it's April 15th, send your 3rd month notice. And remember that information that was pasted into the statute that says, here's all the information, project name, my name, how much money I'm owed. That's all you got to send in that 3rd month notice. Just send it, okay? And we're going to go over the method in which you send it is also streamlined, so that's good news too. You're going to be really excited about that. And it just tracks and tracks and tracks. You know, and my view of it too is that on projects, you're typically working January, February, March, April. And if you're not getting paid in January, you're probably not getting paid in February. Probably not getting paid for April or March and all that. And so what I would do is I would continue to each month, I would either send the notice as ongoing, right? You don't have to file a mechanics lien. Like if you don't get paid in January and you continue working, you don't have to send the notice, file the lien. And then for February, send the notice, file the lien. That's illogical, right? Like it would be way too much work. And so what the code says is that if you don't get paid here, send this month notice, okay? If you don't get paid here, send this month notice, send this notice, send this notice, send this notice. Then, if you stop working here, just go down, send your notice, and then you have all the way until down here to file a mechanics lien for all of it, okay? As long as you sent your notices, it's rolling. It's rolling, okay? Yeah. I hope that makes sense, okay? This is an interesting topic. Okay, basically all these concerns, what they say is, they say, damn, y'all guys took away the 2nd month notice. That was huge leverage for us because we got to send notice to someone and say we weren't getting paid, and that's how we extracted a lot of payments. Well, why would you stop doing it? You know, I don't understand why you would stop doing that. You don't have to. The statute doesn't say you can't, okay? So when I'm sending mechanics lien notices on behalf of Trivan, Dave and Sherry's company, like I've told Dave from the outset, my example letter is really pretty filthy in comparison to what the statute says. Yeah, I include that up here, but then I also have this long, scary letter that has all the old stuff to it, and we can send it on the 15th day of the 2nd month and the 15th day of whatever month you want to. And the statute just says these are the bare bone requirements. I always would lean towards being way more aggressive and sending whatever the hell you want to if you think it's going to extract payment. So these concerns, I think, are completely invalid. You know, I'm not even going to say that. Okay, so here's how you send the notice to. It used to be, under the old statute, it had to be certified mail, return receipt requested. You had to have the counter stamp. If someone challenged it, it was a complete pain in the ass. And I can't tell you how many times as a really young lawyer, when I got, 15 liens dumped on my desk the day of, and we're working all the way through, and 10 of them got delivered in the mail at the office, and then 5 of them I had to drive out to the post office and have them all counter-stamped, and then we had to maintain copies of them in the file because people would challenge it all the time. I mean, it's ridiculous. So now you can email them, okay? As long as your proof of sending it is traceable, then you can do it, okay? That's really convenient, right? And honestly, that's how most of us are transacting and sending notices to people. Just send an email. So I would highly recommend that if you have read receipts, right? If you know how to use read receipts on your emails, delivery receipts, I would enact those when you send these types of notices. And that way you can say, yeah, look, here's my email proof. It was delivered on this date and it was read on this date. These guys got it, okay? So that's one way you can do it. You can deliver it in hand, and you can also send it via FedEx if you want to, if that's more convenient for you. But you don't have to do USPS anymore. That's the takeaway. Does anyone deal with specially fabricated materials? Do y'all know what that is? Anyone have questions as to what it is? You do? Okay. Okay, so specially fabricated materials would be anything that's specifically custom made for a particular use on a project that has no value or use on any other project. You couldn't take it off the project if someone didn't pay you and sell it to someone. It's made for that project. The old statute was really cumbersome. They said that when you manufactured it, before the work even started or you delivered it or did anything, like right when it happened, you had to send notice right off the bat, and everyone missed it all the time. It was like before you even did anything, you had to send notice, okay? It was kind of like the California approach to mechanics liens, which is before you even step foot on the job, file your mechanics lien notice. But that's kind of the way it was, okay? So under the new one, it says not later than the 15th day of the third month after the month during which the undelivered specially fabricated materials would normally have been delivered. So this is where the legislature fails us, because they always do, when they write these, because they're not lawyers. And I don't know what the hell that means. I really don't. So it's totally gray. So to me it means do whatever you want. Do whatever you want, make the argument. No specially fabricated lien notice is getting invalidated because someone's going to prove that you should have normally delivered it on this date. All right? It's all gray. There's an argument to be made by some lawyer somewhere. Don't worry about it.
If it has to be metal fabricating and
Yes.
pre-fabricated.
Yeah.
So that in the commercial world,
It is powerful. And so I just want you to know that the way that what they've done is they basically have rolled it into everything else. It's not specially set aside. Okay, so the new statute, when you open it up and you're looking for retainage and you're saying, well, where is the retainage language? Well, it's not there anymore. It's called reserved funds. Same thing, okay? And everyone knows what retainage is, right? It's the 10% that's withheld by the owner on a project. So for those that don't know, on every single construction project in Texas, residential or commercial, there is a requirement by the code that the owner of each project withholds 10% of the contract balance, the overall contract balance. So if it's $100,000, they have to withhold 10%, so they withhold $10,000. That is designed to protect them and the contractors that don't get paid. And it is also designed to cap their owner's liability at $10,000 if they comply with what they're supposed to do, okay? Because once they receive notices from you, if they don't withhold funds, like we talked about earlier with the trap fund notice, then they're liable for any mechanics lien that gets filed on the property, even if it's $300,000. And extra work and extra materials and all that, they're liable for everything that gets filed. So they have their own requirements they have to follow through. So retainage is important because if the owner is properly withholding retainage from you, from the GC on a project, or you if you're the original contractor, then that money's being withheld and you have a responsibility for sending notice and trying to trap that and file a mechanics lien on that. And it all kind of rolls into, from my perspective, the overall money that's owed to you anyway. So as we talk about like what my general approach is, we'll cover that also. But I also want you to know that a lot of projects I see pushback, whether it's a $30 million industrial construction project, which I've seen a couple times over the last 2 or 3 years, and you see owners pushing back and saying, well, I'm not going to withhold retainage. I don't want to deal with it. Okay? Well, that exposes them 100% to every mechanics lien that's filed. So that's good news for the contractors. And if you're on a project where the owner hasn't withheld retainage, just know that if you file your mechanics lien, that you're going to be entitled potentially to recover your entire mechanics lien balance, even if there's 50 other contractors you're competing with. Okay? It's recoverable in total. Now, if they comply with the statute and they withhold retainage or reserve funds like they're supposed to, and there's 50 mechanics liens out there, well, they're going to take whatever their liability is, $10,000, and they're going to divide it by 50, and everyone gets a pro rata share, and you might get $2 out of it. Okay? So it's good news if they don't withhold retainage. Form of notice, just add this stuff in there. You know, look at the code. It says, the same sheet that I had on there, where the code where it says, here's all the information, I haven't been paid, just add a line. Add this line there. It says total retainage unpaid, and just put it on there to whenever you send a notice. It's that simple. This is some basic stuff. I want you to know that there's this misconception that mechanics liens all have to be ink, wet ink, and you have to take them down to the county clerk, and they have to record it and give you back a copy. And yes, it used to be like that, but now essentially every single major county that you're going to be doing work in, they e-file, and all you need is a signed copy and a PDF copy of it. So like when Dave, for example, files a mechanics lien, he signs it, sends us a PDF copy, we record it electronically, boom, you print it out, it's recorded. And it is public record, and it does have to be under oath, so you can't lie about what's in the lien affidavit. All right, contents. Y'all guys have seen this before. These are hard and fast items that have to be included in the mechanics lien affidavit, or it'll be invalid. If you don't have a legal description, how can they record to the proper title, the proper real property title? If you don't have an owner's name or address, it doesn't count either. You got to have all of that. You got to have the months worked and performed. Okay. You got to describe the work that's done. It could just be, that can all be captured by an invoice you attach to it. Nowadays, the courts are very liberal about saying what constitutes notice. If you file a mechanics lien affidavit and you have included your invoicing as an exhibit, it's going to have months worked on there. It's going to have the amount of the claim on there. It's going to have the type of work that's done on there. It's going to cover a lot of bases, all right? That's a really good tactic for, it's going to have your name and address on there. It's going to have everything. So I also highly recommend that you include your do what now?
The one homeowner be on there? Or
Both. I would. Yeah, if you're doing homeowner stuff.
match the appraisal district, basically.
Yeah, and we're going to talk about that too. So, the appraisal district is a really good resource. I also highly recommend if there's particular counties that you work in regularly, get registered with the real property records. The county clerk's office, they manage the real property records. It goes a little further than what the appraisal district does. The appraisal district oftentimes will give you really inaccurate legal descriptions, and it won't sometimes be worst case scenario, you've got a big important job, and you end up recording it against the wrong title. That wouldn't be good, because you can't go back and fix it. So I recommend that. I don't subscribe to the don't use CAD thing. A partner of mine put that on here, but I think it's a great jumping off point. I often rely on it. But if you want to really verify the proper legal description, you're going to find that on deed of trust. That's in the real property records. Okay.
So CAD is the county's appraisal district?
Mm-hmm.
And then the other one is what is filed from the title company?
The other one is those are the actual real property records. Any legal instrument relating to real property gets recorded by a county clerk. Okay, and so like the deed of trust for your home, your office building, anything you do, projects, boom, it gets recorded in there like a mechanics lien by the county clerk's office. That's where those records exist.
So that's a different website to go to for that information.
It is.
Is it still?
You can verify it all.
Is it still free like the?
It is free. Yeah, it is free. In most most circumstances. A lot of the major counties will screw you, but let's see here, deadline to file, but this 15th day, the 4th month, after the last month provided labor and materials. This is about trapped funds. So the one thing that I haven't mentioned and is added in there is that we talked about all the pre-lien notices. You now have until the 15th day of the 4th month to file your mechanics lien affidavit. So the month after you send your pre-lien notice, you file your mechanics lien affidavit. 3 months, 4 months, just remember that. 3 months to send notice, 4 months to file your lien. It's that simple. Oh yeah, so this is the takeaway talk. Just be aggressive about when you do this. Don't sit back and wait and say, oh, I'm going to see if they pay me. Someone called me and they promised me that they're taking care of this. Oh, it happens to be the 14th when they promised me that they're going to pay me the next day or on Monday. I'll wait and see what happens. And then they don't pay you, and magically they don't answer the phone, and they ghost you, and then all of a sudden you're out on your mechanics lien. Just make sure that I just strongly advise, like, anyone that gets mad at you for filing a mechanics lien is completely ridiculous, and it doesn't often happen. I mean, it's just, especially if you're in the commercial world, it's just part of doing business. You just got to be aggressive about it. You got to protect your rights, okay? So my rule of thumb is that if you do work on a project and you submit a payment application and the project payment requirements are pay me in 30 days after I submit the invoice, and it's the 31st day and you haven't received payment, send the notice. Just don't mess around with it. It sends two messages. It sends a message that you're not going to put up with crap, and you're going to bark, and you're going to get paid. You're going to be a pain, okay? And the people who aren't doing that are the ones who they'll say, oh, okay, well, I can single these guys out. I can slow pay these guys because I got to pay these guys. I just really highly recommend that if you don't get paid on your normal invoicing, you don't have a payment application process. It's not an ongoing project. You go out and you do work, and you don't get paid, and your payment terms are 30 days, okay? And it's that 31st day. Send the notice. I mean, hell, file a mechanics lien if you want to. You don't have to wait until the 15th day, the 4th month. You can do whatever you want to, you know? Apply the pressure if you have the ability to. Sometimes there are relationships that you have to manage. If you have an ongoing relationship with a customer that sends you work, whether it's commercial, residential, whatever it might be, and you don't want to intrude upon it, just wait until the deadline's then. And just say, hey, our company policy is we comply with the lien statute deadlines because we have to, and if we don't, our bank or whatever whoever you want to blame it on, our lawyer will get mad at us, and we'll have to answer to our source of financing about why we're not following through and getting paid on our AR. Whatever it might be, you want to make it up. Just stick by the deadlines, okay? So either be super aggressive or abide by the deadlines. And when the work is done, you also need to know that on a project, when the work is wrapped, you've got basically 30 days. That's the rule of thumb, okay? So when a project is done, file it within 30 days, send a notice within 30 days, take care of your business within 30 days. Don't mess around with it. Don't wait, don't think you can wait month, 2, 3, you can't do that. You got to do it within 30 days of the project wrapping up. Post lien notice, if you file a mechanics lien affidavit, you have 5 days to send notice. The other thing that I include in my notices after I record a mechanics lien is I send a real nasty demand letter and it says I'm going to sue you too, okay? And that also gives you the right to trigger attorney's fees, because in Texas you can recover attorney's fees only if you send notice and you allow basically 30 days to run before there's an award of attorney's fees, something like that. So this is also your opportunity to say, and I want reasonable and necessary attorney's fees. It's going to trigger your right to recover that too. Statute of limitations has changed a little bit on commercial projects. It used to be if you filed a lien, you had 2 years from the day of recording the lien to file a lawsuit to foreclose it. And then what would happen if you didn't foreclose within those 2 years, the mechanics lien basically invalidates itself and no one has to worry about it anymore. It's of no concern to anyone. Doesn't even have to be released. It's effectively invalid. So now what's changed is you have the residential time frame for commercial work too. There's just one time frame, that's 1 year after you record the lien affidavit. You have 1 year to file a lawsuit and foreclose that mechanics lien. It will sit there and it will jam up someone's title, and it will be a pain, and it'll be a source of leverage potentially, but it'll go away if you don't file a lawsuit within 1 year, all right?
How soon can you do it? You said you had it.
You can file it, you can sue immediately.
Okay, so you can file 1 year and then sue immediately?
Yes. Yeah, which is what I would do. I wouldn't wait around on it. Sometimes it, there are situations, like I do have some clients that do a lot of big multifamily work, and they do it for these REITs and all these out-of-state, ownership groups where it's like constantly changing hands, and they'll let it sit there over the course of a year, and they always get paid because as soon as they want to finish rehabbing those big multifamily projects, they gotta pay the liens. So that's the only circumstance in which letting it sit works. You can extend the period for 2 years by agreement. If there's an ongoing project, you're actively negotiating, actively trying to work out the underlying balance, you can extend by agreement the limitations to 2 years with the owner if you want to. I can't imagine that's ever going to happen. Okay, so talking about bonds. There's two types of bonds related to private projects. If you file a mechanics lien or someone underneath you files a mechanics lien, well, let's just start with this. If you file a mechanics lien, an owner has the ability to go to a surety like Travelers, Hanover, like you can name any surety, and they can provide a bond to indemnify against the mechanics lien. That bond is recorded in the real property records on top of your mechanics lien affidavit, and effectively the surety steps in and they say, for all intents and purposes, I'm the owner now. Okay, it removes the owner from the equation. It removes the real property from the equation. Your claim is now against Travelers and their bond. Okay, so that's who you would then pursue if you ultimately filed a lawsuit. You would sue the original contractor that owes you the money, or you would just straight up sue the owner for the contract balance, and you would name Travelers, and you would name them for a bond to foreclose, or a foreclosure of bond claim, okay? The other thing is they can provide a payment bond. The payment bond must be provided on the front end of a project. A payment bond under the property code effectively replaces the whole mechanics lien process. Even though you still have to abide by all of the same requirements, you're not actually filing a mechanics lien affidavit anymore. What you're doing is you're just filing a claim against a bond by notifying a surety. It's very similar, basically identical. Statutory payment bond, if they're going to have a bond on a project, using as an example, they're at the beginning of the project, it has to be basically a penal sum of the contract. So if your contract is $500,000, they have to get a bond for $500,000, and they've got to report it in the real property records against the property so that everyone's put on notice that there's a bond. This is where your suppliers would go to file a claim. If you don't get paid and you don't pay them, they would go to the bond. Okay? Any mechanics lien affidavit that would be filed would be basically rendered invalid and transferred over to the bond. The bond would capture all the liability. And in this situation, the owner has zero liability with a payment bond. Same procedure, like I was saying, as the mechanics lien process with a private payment bond. You can obtain the bond by asking for it, sending it in your notices, asking for all the requisite information that you need. Basically, all you really didn't do anything, just get a copy of the bond. You can also get it through the real property records. You can look it up and find it just like you would finding a deed. Now, this is the lien, the indemnity bond for lien. They're expensive to obtain. Basically, you have to get a bond. If someone files a lien, you have to get a bond that's 110% of the lien amount to remove it, right? And then there's like a 2% premium. So, and that premium has to be paid every year that bond is in effect. Public payment bond claims. Anyone do any schoolwork or anything like that, deal with public payment bonds. Okay. 2253, the government code, it's called the McGregor Act. It's simpler than the mechanics lien process because you don't have to record anything. Under the federal guidelines, there's the Miller Act, which is even easier, way easier, because you send one notice and it captures everything. All right. So this statutory overall didn't change anything related to bond claims. General rule of thumb here is that every single month, the only difference between payment bond claims and canceling claims, and this applies to work on school projects, any type of public building, any type of institutional, city, government-owned building, anything like that is where public payment bonds are going to be, because they're required by law to be in place, so you're going to have a period in. The 15th day of the second month for 15th day of the second month for sub-tier people, 15th day of the third month for higher tier. I just recommend doing the 15th day of the second month for everybody. It accelerates the process, and also the difference being with payment bond claims, if you don't get paid in January, you got to send it by March, and then every month you work thereafter, you have to send ongoing notice to the surety, and all they do is they say, okay, you got one for this month, add it on top. You got one for this month, add it on top. That's how it works. And when you send notice to a surety, you're also effectively like going through the whole mechanics lane type of process, because in your notice you include an affidavit of sworn account, which looks just like a mechanics lane affidavit. You also have an itemized statement of account, and you also have your invoicing. It's the whole package. Like this. Basically, everything's a mechanics lane affidavit. If you don't have a written contract, it doesn't matter. I say that for everything. Texas is incredibly liberal about mechanics liens being valid. You can recover attorney's fees in Texas if you have a handshake with someone. Okay. You can also recover interest on a verbal contract. If someone says, "Hey, do my roof, I'll pay you X," you can recover interest on it too, 6% interest. Okay. Here's some statutes that are good tools for you. Texas Private Prompt Payment Act. This is the more powerful of the two. There's also a public version of this. The private says that once an invoice is submitted, the owner has 35 days to pay it by statute. If you're on a commercial project, it's powerful because if they don't pay it, then you can walk the project. You can say, "I'm done. I'm not going to do anything until you pay," and you can walk off and you're not breaching contract and protect yourself. If they do pay, the GC's got 7 days from the date they receive payment to pay you. If they don't pay you in that time frame, you can walk the project. You got to send notice. It's in the code, but it allows you to protect yourself without getting terminated. And they can still terminate you.
It's private pay, is the private, it's going to be like a private.
Anything that doesn't involve
Government.
public, yes, a government-owned institutional type facility. The only exception to this is that if there's a good faith dispute. So whoever hasn't paid you can say, "Well, I didn't pay them because they messed X, Y, and Z up." It's got to be legitimate though, because if it turns out it's BS and you know it's BS and it's just an excuse for them not paying you, ultimately the penalty is that you recover attorney's fees and 18% interest for starting every day that they haven't paid you. It'll run. So if they want to play out this fake dispute for a period of 3 or 4 months, you recover 18% interest over the course of that time frame. Okay? It's a very strong tool. I include that in most every lawsuit I file. I include it because why would you not? Public Prompt Payment Act is kind of the same, except what really sucks about it is that you get 1% plus prime interest. So you're getting like sometimes less than even the contractual percentage. It's not great. The Trust Fund Act, I could do an entire presentation on this alone. Okay, this is something that can land you in jail. It's not great. It can give you non-dischargeable liability in bankruptcy court. Anyone in here that touches money is impacted by this statute. Okay, but it also is a tool for you against people that owe you money. You gotta be very cautious of this statute. I highly recommend that you guys are familiar with it. It's chapter 162 of the Texas Property Code, and it's been in effect for quite some time. And the courts have started to, we've got now like a 20-year history of court interpretations on the statute and about how it impacts people's personal liability. But statute says is any owner, or, well, not even necessarily owner, okay, let's say an owner that finances a project, they get money from a bank or some alternate source. That owner is a trustee of construction trust funds. If there's a GC, they are a trustee of construction trust funds. And then the people they owe money to are all the beneficiaries of the money. What the code basically says is that money is the property of all the beneficiaries down here. And you guys have no right to it, other than you have a responsibility to make sure they receive it. And if they don't receive it, you divert it somewhere else, wrongfully withhold it from them, you never pay them, you're basically committing fraud. Okay? And there used to be criminal liability associated with this. And ultimately, it doesn't do that. So that impacts anyone that touches money. You don't have to be an officer. You don't have to be an owner of the company. You don't have to be anything special. You could be a bookkeeper. You could be a superintendent. But if you manage funds and they come in and they flow through you and you don't pay people properly like you're supposed to, and there's really no excuse for it, boom, you can get hit with the Texas Trust Fund Act violation, which means you're breaching the fiduciary duty. And the fiduciary duty standard under Texas law is the highest standard that exists. As a lawyer, there's only a handful of situations in which a fiduciary duty is owed to someone. Lawyers owe fiduciary duty to their clients, doctors owe fiduciary duty to their patients, and you kind of get the idea, right? But then all of a sudden, someone who's touching money on a construction project owes you as a recipient a fiduciary duty too. So if they breach it, it's rather significant. If you're able to be successful in pursuing a trust fund act claim against someone on a sizable amount of money, and you get a judgment against them, it's non-dischargeable in bankruptcy court, so they can't get away from it. Okay? It's always powerful, and if you're in a bankruptcy situation where someone files and doesn't seem like there's any likelihood of recovering, been extremely successful over time, filing proof of claims in bankruptcy court for those balances and saying, it's not property of the bankruptcy estate, it's my property. Under the Texas Property Code, you're not entitled to receive it or keep it, okay? And we've had money disgorged from bankruptcy trustees in multiple situations where the bankruptcy courts and the federal courts have treated it as, yeah, it's not this bankruptcy estate's property. Okay, it's a very powerful statute. Like I said, I did an entire presentation on it. Here's just a cool one. This really doesn't have so much to do with mechanics liens, but I want you to understand the power of formality in certain circumstances. This is a case about notice of termination, and it's a recent case, and it's kind of a really interesting decision. So you have this company, James Construction Group versus Westlake Chemical Corp. And our firm actually represents Westlake Chemical Corp, not in this matter. Okay, James contracted to perform civil and mechanical construction work in this facility in Louisiana. They terminated him for safety violations. They gave him 3-part notice. You can read it, okay? And the contract required that all the notices be in writing. So, the owner, Westlake, they sued James for safety violations, failing to cure them damages caused by termination. Jury awards over $1 million in damages. Houston Court of Appeals affirmed the award and held Westlake substantially complied. So you really think you're dead to rights. Well, they got appealed up to the Texas Supreme Court, and the Texas Supreme Court said everyone's wrong. The Court of Appeals, the trial court, Westlake, you're wrong, okay? And this is what the court found. They said, well, the first notice was questionable. Like, you guys aren't even really providing actual notice. Like, you're not detailing what they did wrong. You're not detailing why they should be sufficiently noticed for termination. There was no second notice because all Westlake was doing was they were just sending emails to them. And I want you to understand that just because you can send an email for a mechanics lien statute doesn't mean that it excuses all formality. You don't just send an email to a subject line and just hope they get it and say that complies. And basically it said because of their emails and conduct, there was no second notice, and there was required to be a third notice, and it wasn't even in writing. And so the court said actual notice is not a substitute for written notice, because what Westlake was saying was like, well, they knew about it. They knew about it, okay? We talked about it. So they were well aware of the safety violations. Everyone on the project knew that these guys were committing safety violations. And so, you know what, it really didn't even matter. We didn't even really have to provide proper notice. So I want to apply that to the situation in mechanics canceling is paying the bond last. You guys are gonna say, well, the owner knew that they hadn't paid the GC. The GC knows they hadn't paid me. So everyone knew they hadn't been paid. So that's why I didn't have to give notice on the 15th day of the third month. That's why it's okay, because everyone knew they owed their money. Well, that's not the way the law operates. Make sure you send the notices. They're super basic now. You know, if you have a lawyer that you work with and you trust, and you want them to verify that you're doing it the right way, do it. If you want them to look over, you know, larger, more important mechanics liens or bond claims, do it. But don't not do it. Don't not do anything. Like, just that is the worst thing you can do, is doing nothing and letting everything go by, and, you know, all of a sudden you're just out of luck, all right? Let's see here, we've got no minutes. Does anyone have any quick questions? Go ahead.
So under the Texas Construction Act, where does the source of the money have to be? Where does it have to be for the project? Does it have to be
From a lender.
From a lender.
It has to be from a
Not
lender.
right under, but from
Any lender.
any lender.
Any lender.
If I privately financed,
That doesn't count.
that is.
If an owner privately finances a project, then it doesn't count. That's not going to apply
Some
to,
kind of,
it's not going to apply to an owner, but it will apply to the downstream.
okay.
Okay? Yeah, private financing. Okay, so, and I've got my contact information up here. Anyone wants this information, let me know. I'm happy to email the slideshow to you and provide whatever other information or answer any questions you ever have. So, anyway, thank you for attending, guys. Appreciate it.
If you happen to miss the mechanics thing, what other options do you have after that? Is that it?
You know what I will do, the one thing that I did.
And I'm hoping not to, I mean, that's not my point, but I mean, sometimes, you know, we wait on insurance or something happens and it's just like, you're just getting a bad spot. Cause I'd hate to do all this and then like, it's like, they're waiting on the insurance company or the mortgage company or something like
Yeah,
that.
it happens sometimes.
Yeah.
There's one tool I didn't talk about that relates to mechanics lien. And under the Texas Constitution, you can record a mechanics lien. If you have a mechanics lien that you don't even have to actually physically record against owners on a construction project. If you're an original contractor, meaning you work with the owner directly and they owe you the money, you can file a mechanics lien. One already exists, but you can also file one. You can do that anytime you want to, because until the debt's extinguished, that mechanics lien right exists into perpetuity. Okay, it could last for 100 years. The only problem is you gotta foreclose it within some period of time. So what I tell people is that you basically have up until almost like 4 years. If you want to record a mechanics lien affidavit, and I kind of get someone's face by saying, you owe me this money, I'm not letting you go, you can record a constitutional mechanics lien. You better foreclose it within that time frame.
We were informed that in order for us to be able to file a suit against a residential customer, we had to file a copy of our signed contract with the county clerk before we even started the project. Is that
That's
true?
that's part of how you are able to file a mechanics lien. Yes, I didn't get into all the residential stuff because I don't do residential stuff for very intentional reason. And part of that is that yes, you have to get the contract signed by husband and wife at their property with all the notices that are required by Chapter 53, subsection K under the property code. And then you have to go down and you have to record your contract in the real property records, like you're filing a mechanics lien. Before you do any work on the project, you cannot commence any work and then record the contract. You have to record it from the outset.
Before you can file a mechanics lien,
Before you can even file a mechanics lien or anyone underneath you can file a mechanics lien.
or you're going straight to sue if something happens.
Yeah, you can always sue them for
Yeah.
whatever you want to. Yeah, but that's how it relates to mechanics liens.
JP, if they give you their business card, can you send them the?
Absolutely, I can do that.
Okay, coming around for applause for. If you want to give your business card to JP, he'll give you a copy of the, deal. I can tell you this, how many of you had done a commercial project this year? How many? Okay. We do quite a bit, and what we found out, and we were actually told by a general contractor, that their customer intentionally, because interest rates are high, money is tight, they're intentionally not paying that retainage, hoping to get past that lien period, then they don't have to pay it.
Yeah,
Right, JP?
very true. Money's weird right now.
So this is incredibly important, and thank you for JP coming out from Dallas to do this, to help you guys, and of course, he's always available. But it's a real thing for us contractors here in Texas, with money tight and these guys doing it. I think we've got, we're out $50,000 on a project because of this. So they're intentionally not trying to pay us, or not just rippers, anybody.
I was gonna ask, can you touch on the federal Miller Act real quick? Because we have one that,
Okay, so for Miller Act, you basically send a letter. You don't have to include all this additional sworn statement of account, itemization, all that stuff, even though I do anyway. It's better to provide more notice. But under that statute, it goes to a surety, like the McGregor Act does, except you send it by within 90 days of doing the work. That's it. That's the simple deadline. You're done, you got 90 days, send the notice. You got a federal Miller Act.
so if they start paying and then they stop paying, you have to refile? I mean, how do you,
You just amend your claim.
okay.
Yeah, yeah. I didn't get into all the, like, I could do a presentation on
Yeah.
McGregor Act only, Miller Act only, because there's all these procedures. But, you know, these are kind of the really high-level stuff. So if you have any questions that are more specific, just email me.
Okay.